Hello everybody, welcome to EPG Pathshala. I am Monica Sakrani and we are doing the course Legal Literacy. We are looking at the module on family law. This is Family Law 1 and here we will be looking at the law relating to marriage in India. So as most people know that in India the family laws are determined on the basis of, that is, law of marriage, divorce, inheritance is determined on the basis of the religion we belong to. This is known as personal laws also. So what are personal laws? Personal laws is that my rights within the personal sphere of my life are determined on the basis of the religion that I belong to. Now, before the British came, the basis of family law or what really applied to people was not necessarily on grounds of religion. It also, your caste and your region also determined what your status and what your rights were and what kind of marriage you had, what kind of inheritance. So we all know that there are matrilineal societies in India which may be Hindu, but there are patrilineal societies, also patriarchal societies, which are also Hindu. So there are differences based on region and community to community. But the British basically decided to bring in a kind of a uniformity into all the laws, and so decided to govern people on the basis of the religious identity that they had. And then that became the way things moved on. So the first lot of religious laws, so the parliament also started passing, over the years the parliament also started passing laws for different religious sects with regards to the family laws or the rights within the family. Now the first law which actually came about was, interestingly, the Parsi law. Now in 1832 there was a Lex Loci report which was brought in, which said that all non-Hindus and Muslims will be governed by English law. Now the Parsi community suffered as a consequence of that, because there was a case of a woman whose husband died, and under the Parsi law she was entitled to inherit the property, but under the English law she was not entitled to inherit the property. So the Parsi community decided that they wanted a separate law of their own which will govern their community, and they brought in a law. Later on, the Christian law was codified and the Indian Christian Marriage Act of 1872 with regards to marriage, and the Divorce Act of 1869 which was amended in 2001 was passed by the British. Now this law was very much the law which was there prevailing in England at that particular time. So the matrimonial law in England was replicated in the Indian Christian Marriage Act and the Divorce Act. The Parsi Marriage and Divorce Act was amended in 1936. In 1937, the Muslims also asked for a law for themselves, and they brought in the Sharia Application Act. So the Muslim personal law, so the Muslim personal law now became the Sharia law, started applying. So earlier Muslims also would be would follow customary practice as against Sharia. So then after 1937 they started following Sharia. Another act which was brought in 1939 was the Dissolution of Muslim Marriages Act, which only applies to Muslim women. Muslim women have the right to go to court for divorce. Muslim men cannot go to court under this law. The Sharia law applies to them. After independence, two new laws were brought in. Now what had happened was that some kind of demand for reforms within the communities were being brought in, were being demanded, and post-independence and this demand from women's organizations, women who started participating in public life, also started saying that we want more egalitarian laws governing our communities or our life in our personal sphere also. So because in India the majority of the Hindus were still governed by Hindu customary law, many of the upper caste Hindu women, for example, did not have the right to divorce. Polygamy was permitted. They had no right to inherit property. So there were certain demands which were brought in by them, Now, their demands were formulated along the lines of the English matrimonial laws of that time. So, in 1955, the Hindu Marriage Act was passed, which gave which brought in monogamous marriages, but also brought in the right to divorce for many women for the first time. And the second law which came about was the Special Marriage Act, which was a civil law of marriage. Irrespective of which community you belong to, you could get married under that law. Now, if we look at all the marriage laws, there are distinct marriage laws for all the communities, but apart from Muslim law, most of these laws are actually based on the English matrimonial law, and the changes which have come in over the period have also been based on the changes which have come in the Western world. So even though we say that we are governed by personal laws, we are largely governed by by the same law going under different heads, under different names, and they apply to us. So there is a lot of similarity in all the personal laws that are applicable in India. Now we will look first at Hindu law. Now here in this slide you will see the term valid marriage. Now marriage itself, once you bring in the law, and the law brings in certain conditions of what is required in a marriage, like for example monogamy. So if you're saying that a person who's not married to somebody else only can get married, if a person who's already married gets married, then that marriage itself, it may be a social marriage, it may be a religious marriage, but it's not a legal marriage. So there are three types of marriages which is based on the contract law. One is what you call valid marriage, that is a marriage which is recognized in law. Then you have what is known as a void marriage, that is a marriage which contravenes all the conditions of law and the law does not recognize this marriage. So even if I'm married to somebody, I can't go to court and exercise my legal rights because the law does not recognize my marriage. And the third type of marriage is a voidable marriage, which is that it violates certain conditions of law, but the law gives me the option of getting out of that marriage or remaining in the marriage. So for example, the child marriage, if I am under 18 and I get married, I have a right to get out of that marriage up to the age of 20. If I'm a boy who's gotten married below 21, I have the right to get out of that marriage by the age of 23. But if I continue to remain in that marriage, my marriage becomes a valid marriage. So avoidable marriage, one has the option of getting out till a particular time, and after that the marriage converts into a valid marriage. So we shall look at what is the Hindu law of marriage. Now the first change that the Hindu law made was, because one has to look at Hindu law as a social reform which was brought in. So one has to look at the first thing that it tried to do was unite and bring everyone into a reformed law. And so the term Hindu itself is, and the second thing that it tried to do was reform the law of marriage within Hindus. So the caste-based customary laws with regards to marriage, where people couldn't marry outside of their caste or inside the gotra. So Sagotra marriage, which was what one calls caste endogamy and gotra exogamy, this was tried to be done away with, and with the reform of the Hindu law. So one way of doing that was the way you define a Hindu, and you allow a marriage between any two Hindus. So it defined a Hindu in two ways. One is that anyone who is not a Christian, Muslim, Jew or Parsi, and anyone who does not belong to any of these four religions is a Hindu. And a Hindu is someone, no matter which sect he belongs to, including Jains, Buddhists and Sikhs. So all sects of Hinduism were brought in, and anyone who is a Hindu could get married to another Hindu irrespective of the caste. So this was the way in which Hindu marriage was sought to be reformed. But another way that Hindu marriage became reformed was that upper caste practices became the norm in the marriage ritual itself. So Saptapati, which was just one of the forms of marriage, there were 8 forms of Hindu marriage. Now certain the forms which were more Brahminical in nature became the legally recognized forms of marriage. So for example, Gandharv Vivah, which was a man and a woman get married without any kind of religious ceremony, just by exchanging garlands or starting to live together is now not a recognized form of marriage at all. So it is seen as a live-in relationship rather than as a marriage form. So the Saptapati has become, or the 7 steps around the fire have become a must for valid marriage, though the law has been amended over the years to recognize certain other forms of marriage. Like for example, in Tamil Nadu, there is the self-respect marriage where which is done without any kind of Brahminical rituals. So the Hindu Marriage Act recognizes these kinds of marriages. Now, what are the conditions of a valid marriage under Hindus? It has to be between 2 Hindus. Both should not be married at the time of when they get married. At the time of marriage, neither party is incapable of giving valid consent. So both the parties have to be of sound mind, and in order to be able to give valid consent, and neither party, though capable of giving valid consent, has been suffering from mental disorder to be unfit for marriage or procreation of children. Apart from that, the other conditions are that neither of the parties has to be subject to recurrent attacks of insanity. So one is that consent has become very important in marriage, and what is your mental condition of consent has become, as I told you all, that this has come from the British law at that particular time. The other thing that came in was the age of marriage was fixed. Bridegroom has to be 21 years of age and the bride is 18 years of age at the time of marriage. Another very important requirement in all marriages is that certain relationships are prohibited. So you cannot marry your mother, your father, your son, your daughter. You can't marry brother and sister. You can't marry uncle and aunt, grandparents, grandchildren. So there are certain kinds of relationships which are prohibited degrees of relationship where you cannot get married to each other. And this is true of all laws. There is a list which is given in all laws where you cannot marry each other. And amongst Hindus, there's another category where you cannot get married, that is sapindas. Sapindas are 3 generations from your mother's side and 5 generations from your father's side. So for example, I cannot marry a person whom I'm related to through a woman. So it can be my grandmother, it could be my mother, if it is up to my second cousin. So I cannot get married to that person, and from my father's side up to 5 degrees. So if both the lines are related to each other through the father, then up to 5 degrees you cannot get married, except if there is for prohibited relations and sapinda, if there is a customary practice within my community of getting married to that person, I can get married. So for example, if in my community first cousin marriages are permitted, then I can get married, but I have to show that it's a valid marriage. Now certain conditions which are not fulfilled, if you get married within those, violating those conditions, and your marriage is void. Otherwise, it's a voidable marriage. Now, which are these conditions? Prohibited relationships, sapindas, and if you are already married to somebody else. So if it is your second marriage and you're not divorced, then your marriage is a void marriage. Apart from that, if both the persons are not Hindus, then the marriage is a void marriage. Now, what makes a marriage voidable under the Hindu Marriage Act? One is that if the marriage has not been consummated owing to the impotency of the respondent. The second is that if it is in contravention to any of the other clauses, that is, if I am incapable of giving consent, then that would amount to avoidable marriage. The consent of the other condition for voidable marriage is if the consent has been given, but the consent has been obtained by force of fraud, then in that case the marriage would be voidable, but it has to be presented to the court within a year of such force or fraud ceasing. Or if I have lived with my full consent after the fraud or the force has ceased, then in that case I cannot go to the court and ask for a divorce or ask for an annulment. In case of a voidable marriage, you don't ask for a divorce, you ask for an annulment. So you move the court for annulment. In case it's a void marriage, then you don't need to go to court. You can go to court and get the marriage declared void. but even if you don't do so, you can get married again. But in a voidable marriage, you have to go to court and get an annulment before you move on and get married again. And if you don't go to court, the voidable marriage gets converted into a valid marriage. Now, the other condition for voidable marriage is if a woman is pregnant at the time of marriage by another man, and she gets married to the other man other than her husband, and the husband discovers that only after marriage, then he can move the court for annulment, provided he has not lived with her voluntarily after coming to know that the child is not his. So then he can go to court and get his marriage annulled. Now, one of the important things that the Hindu Marriage Act does is, despite the fact that it has brought in the issue of void marriages and monogamy, it still makes children of void and voidable marriages legitimate, and they have the right to inherit from their father. So the children are still, that's why if one looks at bigamous marriage figures, one finds that the maximum number of bigamous marriages are amongst Hindus. So one of the advantages of even having a marriage as against a live-in is that your children's rights are protected and they are considered legitimate, and they have the right to inherit from both the parents. Now, under other laws, what are the conditions of marriage? Now we look at Muslim laws. Now, in Muslim law, unlike other laws, Muslim law is unique because marriage was always treated as a contract between two individuals who were consenting to live together, and the contract continued till they wanted to live together, and once they decided any one of them did not want to be in the marriage, they could opt out of the marriage. Unlike other laws, both Christian and Hindu, which treats marriage as a sacrament which lasts the lifetime of a person and even beyond the lifetime. So, for example, amongst many upper caste Hindus, widows were also not allowed to remarry because the marriage continued till the time she died and not just the husband died. Whereas the Muslim marriage comes to an end when either of the party dies or when they get a divorce. So divorce was always a recognized part of Muslim law. Now, what is required, because it's a contract, what is required is that there is an offer and there is an acceptance. So the offer is called an ijab and the acceptance is called a kabul, and both should take place in the same meeting, and it should be witnessed by two witnesses. So that is what is required. There need not, even if there is no priest and there is an offer and acceptance and a nikah nama has been signed by both the parties, then that is a valid marriage. Now, one of the other differences between Hindu law as against other laws is that a Hindu marriage need not be a registered marriage. So it's the ceremony or the rituals are more important than actually a written document. Whereas in other forms of marriage, a written document is also plays an important part. So many of the Hindu marriages are not registered. There's no proof of marriage apart from the word of the parties, the witnesses who were there, and and the photographs if they are there, etc. Whereas in other forms of marriage, there's a document which has to be signed. In Muslim law, it's called the nikah nama. The nikah nama has to be signed by both the parties as well as the witnesses who are there. The other unique feature of Muslim law is that prenuptial contracts, which are not recognized in all other laws, are recognized in Muslim law. So one of the conditions of marriage could also be what is known as, and another important aspect of marriage contract is the meher amount or the dower amount. This is different from dowry because it is an amount which the husband pays to the wife in consideration for the love and affection for the fact that she has become his wife. He is paying her some amount of money. Now, dower can be paid either at the time of marriage or after marriage, but it is a debt on the husband. So even if the husband dies, the dower amount has to be paid to the wife first as a debtor, and then she will inherit from him as a wife. So the dower is an important feature of, or the meher is an important feature of Muslim law. Now, there are a valid marriage under the Muslim law is called a Sahih marriage, where two people generally should belong. It is not necessary that a Muslim man marries only a Muslim woman. He could also marry any woman who is known as a Kitabiya, who follows the Kitabiya religions. The Kitabiya religions are those where a woman, like for example, the Christian woman for whom text is of importance. So, and the other condition which is important in a Muslim valid marriage is the fact that there should be a consensual, that consent should be fair, and actually the requirements of giving a ijab and the kabul in the same meeting are there, and it should be witnessed by two people. That would make a valid marriage. Now the void marriages are when you get married to somebody whom you are prohibited from marrying because you're related to that person by blood or by marriage. So there are different, under Muslim law is also very complex because you belong to different sects, different laws apply to you, and because the Sharia applies to you, depending on the sect, there would be different customary practices which are there, which you have to apply to. The other prohibition is on grounds of fosterage. Any woman who has breastfed a child, the man cannot marry her. Marriage with a married woman is void marriage. Then there is a form of marriage which is voidable marriage, which is a fasid marriage. In this, if there is a difference in the religion, then that would be a voidable marriage, unless the woman then converts and gets married, has a Muslim law marriage. Prohibition is there on ground of unlawful conjunction and prohibition on marriage within iddat. Now, iddat is a specific term in Muslim law. Iddat really means that for a woman it is 3 menstrual cycles, or if she has post-menopause then it is 3 months, and if she is pregnant till the birth of a child, that is known as the iddat period. A woman cannot get married during the iddat period. So if once she gets married and she gets divorced or her husband dies, at the end of the marriage she has to go through an iddat period, and she can only marry after that. So if she gets married within the iddat period, it becomes a voidable marriage. So woman cannot get married during the iddat period. Now, because consent is very important in a Muslim marriage, there's a concept of what is known as option of puberty or khayar-e-bulugh. That means that a girl or a person, a child cannot get married. A child who is unable to give consent, that marriage itself will have no validity under Muslim law because the consent has to be there. So you have to reach the age of puberty before you can give a consent. Now, before that, the parent will give the consent, but the child, upon reaching the age of puberty, can take off the consent and can withdraw the parent's consent. So a child who's gotten married before attaining the age of puberty has the option of getting out of the marriage upon attaining the age of puberty. The different courts in India have held that the age of puberty is 15 years of age. Now we come to Christian law. As already stated, this is based on the English law. It is unique in the sense that it allows marriage between a Christian and a non-Christian under following the rituals and the religious prescriptions of Christian law. The Christian Marriage Act provides for the procedure for marriage. So it doesn't provide for what is a valid marriage. That we look at the Indian Divorce Act in order to find out when a marriage is void. But any one person who is a Christian can get married. You have to give the notice to the priest or the marriage officer, and anybody has the right to file an objection to the marriage, and if no objections are filed, then the consent is given and the marriage takes place within the church or any other place, designated place where the couple get married, and the marriage automatically gets registered. So if it's a priest who is getting the couple married, then after the marriage gets over, the priest gets the marriage register signed and sends it to the marriage registrar, who will register the marriage. So that is the procedure for a Christian marriage. Apart from that, what are the other conditions that are required to make a marriage void? If we look at these conditions, we look at them as very similar to other laws also. The respondent was impotent at the time of marriage. Parties are within prohibited degrees of consanguinity, which is listed in the Act. either party was a lunatic or an idiot at the time of marriage. Now you have to understand that this act was of 1869, so the language which is used is quite out of sync with our present times. Apart from that, the former husband, so marriage has to be monogamous in nature, and consent of either party was obtained by force of fraud. So any of these conditions, if they are not fulfilled, it results in a void marriage. But again, children of a void marriage where the second spouse is unaware of the first marriage are, or when one of the spouses is mentally unsound, are legitimate. Parties to a void marriage can perform another marriage without getting a decree declaring their marriage as void, and neither be guilty of bigamy. So in Christian law, these are the conditions which are required. If to be fulfilled, if any of these are violated, then it becomes a void marriage. Now there is no such thing as a voidable marriage under Christian law. Now we come to the last of our laws, which is the Special Marriage Act, which is a secular law or a civil law of marriage. Now here also there are conditions for a valid marriage. The most important condition, any two people can get married to each other irrespective of their caste, community, religious identity. Even foreigners who are domiciled in India can get married under the Special Marriage Act. Condition is that it should be a monogamous marriage. Neither party should have a spouse living. Neither party should be incapable of giving consent, because it is a consensual marriage where two people can agree to get married. It's a contractual marriage. So you should be not be incapable of giving consent due to unsoundness of mind, or you should not be suffering from a mental disorder of such kind as to be unfit for marriage or procreation for children. You should not be subject to recurrent attacks of insanity. Man should have completed 21 years and the female 18 years of age. You should not be within the degrees of prohibited relationships. And any of these conditions, if they are violated, it will amount to a void marriage. And if the respondent was impotent at the time of marriage and at the time of institution of the suit, the marriage would be a void marriage. Now, what are the provisions that make the marriage voidable? If the marriage has not been consummated owing to the willful refusal of the respondent to consummate the marriage. So if the respondent means, I should be willing to consummate the marriage, but if my husband or wife is refusing to consummate the marriage, I have the right to opt out of the marriage. But if I am refusing to consummate the marriage, I cannot opt out of the marriage. Secondly, if the petitioner, this should be respondent, respondent was at the time of marriage pregnant by some other person other than the petitioner. So if the wife is pregnant with some other man, and if the person was ignorant of the facts that the child was not his, and if it is instituted within a year from the date of marriage, because within a year, if she was pregnant, she would have the child. And then if I know that the child is not mine, then I should move the court for grant of annulment. If I do not do that, then the marriage becomes a valid marriage. Apart from that, I also have to prove that the marital intercourse with the consent of the petitioner has not taken place. The consent of the other condition for voidable marriage is that the consent of either party of the marriage was attained by coercion or fraud, and if within a year of the fraud or the coercion ceasing, I should file the case, and I should not have lived with the other person with my free consent after that. So in this module, we have looked at what constitutes valid, void and voidable marriages within the different personal laws. In the next module, we will be looking at divorce, and we will be looking at the debates on Uniform Civil Code. Thank you very much.